During the foreclosure procedure, some people are unclear on this. So and it doesn't matter if it's a homeowner association foreclosure, a bank foreclosure, the foreclosure is a legal proceeding, but until there's actually title that changes hands, either through a regular negotiation or through a legal sale of the property, a judicial sale, so the judge orders it because the property is, the lien has been foreclosed, and then it doesn't get satisfied, the judge sets it for the sale and it goes to auction, and then the judge goes, well, actually it's the clerk's office, they issue a deed for the highest bidder or for the judgment holder if the highest bid does not exceed what is on the face of the judgment. So the reason I'm saying that is that until that deed is signed by the clerk's office and recorded, or unless it's recorded in an arm's length transaction, a regular sale, until that's done, it's still just a legal procedure. The prior owner still owns that property. So up to that point, is the mortgage company required to take care of the property and maintain it? No. It's still the owner's obligation. If the association wants to institute fines, it's against the owner. It's not against the mortgage company. Now, one of the things is that if you read your standard mortgage, it will say that the mortgage company has the right to protect their asset. So they have the right to come in if the home's been abandoned or not being taken care of, and they can take care of it, and then they add those fees to whatever their foreclosure fee is that the owner owes. But until they take title, the association really doesn't have any kind of right to go after the HOA or the condo association for not maintaining it because it's the prior owner. Once they take title, if they own the property and they've foreclosed and the clerk issues the what's called a certificate of title, it's a deed. And once they take deed to that particular property, then they're like any other owner. It doesn't matter that they're a bank. It doesn't matter if it's, an investment company next to you or, a person that's been living there 30 years, whoever owns that property, whatever entity, whatever natural person is obligated to follow the governing documents, including maintenance of that particular property. And if they don't, they can be fines that it can be levied, possible suspension of use rights, and then they could actually face a foreclosure if they don't pay the assessments and they become delinquent in the assessment. So once they take title, they're treated like any other owner. Prior to title, it's the owner that has it that's not paying the mortgage that is responsible for the maintenance and upkeep.